Welcome. Hey, we're live tonight on YouTube. Welcome back, everybody. So I posted a little bit about this meeting, this live stream in the Facebook group so everybody would know what's going on tonight because we got some important stuff to talk about and we're going to get started. So the first thing I want to talk about tonight, I had a conversation with a person filing their documents, and we started talking about the rules. So I want to talk about the rules for a minute. Everybody's running around trying to follow the rules of state court and wanting to switch all of the switch the case law over to state, all of that craziness. Okay, I don't those things aren't in the instructions to be done. So you guys need to follow the instructions of the paperwork, even if you don't fully understand it. So here's the deal. All of the paperwork that I put together to be filed in, I use federal case law. Okay. Federal case law can be used in state court. It's no different than using Supreme Court case law in state court or a federal court. Federal court is a higher court than state court. So you can use federal case law in state court, and I have the case law to support that, and I put it in there. I think I have it in most of the documents. So when you're using federal case law, you no longer have to use state court case law when you're kicking people's butt in state court. Now, remember, in my program, we're only going into state court to jam them up and move out of there and get on over to federal court. Because the state court issue, once you file your title dispute, the state court issue becomes an immediate possession issue. And immediate possession, particularly in eviction court, and immediate possession cannot be determined until the title dispute's been settled. And that's why in the non-judicial foreclosure package, we have it set up to where you can file your challenge to eviction court jurisdiction and then use your notice of removal and just remove everything. You would file a file stamp copy of the document that you file challenge in eviction court jurisdiction to your notice of removal, and then you just move it over to federal court and you tell them to attach it to your title dispute. And if they give you any crap, you tell them the reason you're doing this because your legal team told you that eviction court can only make a determination on immediate possession. They cannot make a determination on the title dispute. So the title dispute is filed in this court. So when this court gets done settling the dispute, then this court can do the immediate possession issue. Because when I get done, there won't be a need for the other court. So that's what you do, and it works out. But when you take it over and you tell them, you got to be talking and acting like that your legal team told you what's up and you understand it and you know it. You can't go in there saying, "Oh well, I think I'm not sure." No, hell no. Even if you don't know what the hell you're talking about, you got to make it act like you know, and this is it. And if they give you any shit, no, wait, look, my legal team told me. So what's your name? Whip out that little notepad. You know the notepad I'm talking about, the one the po-po uses when they have to show up to your house a second time, and they whip out that notepad, and the police started writing down information. Okay, so I watch a lot of TV. That's never happened in my house. Okay, but you know what I mean. You whip out that notepad, and you start asking questions. So what's your name, or your employee number, or something? Because my legal team's gonna need to know. And if what you're telling me is not working out with my legal team, then you can find yourself right underneath the defendants list on my lawsuit. So it's up to you how you want to play this. So one of the things I want to talk to you guys about are the rules. Okay, the rules. There's several sets of rules. So let's talk about the set that everybody's supposed to be following. And they're called the Federal Rules of Civil Procedure. You guys know about that. That's where you need to go and check to find out how long the other party has to answer or whatever, what's supposed to, you know what I'm saying? You go to the Federal Rules of Civil Procedure and you look that stuff up. You do that for state court too, okay? In state court uses the Federal Rules of Civil Procedure, one set of rules. Now, they have another set of rules. The other set of rules they call the local rules. The local rules are put on the books for attorneys. And in my opinion, it's for attorneys to speed things up in court. Right. And the local rules have not been put through the stringent process that the legislature puts rules through to make sure they're in line with the Constitution or the law. So the way you avoid this is you have to look up the filing requirements for your state. Each state has a filing requirement statute, and you need to look up that filing requirement statute. And I would include it in your document on front page, somewhere near the top. Okay. This document has been structured by my legal team according to my state filing requirements located at such a blah, 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 right there. Now, when you go to those filing requirements and look at them, you will see that those filing requirements are liberal. Yep. They don't cover none of that crap that they try to make your ass do when you're trying to file your stuff in court. So when they start telling you, hey, did you wait? I reviewed the filing requirements. See, right here in my document, I reviewed the filing requirements and it don't say nothing about what you're talking about right now, what you're telling me to do right now. It sounds like you're sending me on a goose chase to go run around. Mm-hmm. Now, if they refuse to file your documents, so what you want to do is you want to look at the clerk. Actually, I would ask for the supervisor. And as soon as they start giving you shit, you want to ask for the supervisor. And when the clerk supervisor come up, you want to ask the supervisor. My question to you is, do you have the authority to make a legal determination on my document? And don't say anything. It's like a car sale deal. Once you lay it on the table, I need you to sign right here. You don't say nothing. The first person to talk is the one that's going to pay. And in most cases, when people have done that, if you say that and you just shut up, in most cases, they just take your paperwork and go file it. Because at the end of the day, it's up to the judge to decide if your paperwork should be accepted or not accepted, not the clerk. And if it's not accepted, then the judge should give you a conclusions of fact and letting you know and determination of law, letting you know why your document is not being accepted or whatever. But that's not what they do. So you guys need to remember that when you're trying to file your stuff in court, so you can make sure that you're not being sent on a wild goose chase, and that you get your stuff filed in time to protect your property or whatever it is you're doing. Now, the other thing we're going to talk about tonight, and I'm thinking that this subject is probably going to be several live streams because it's kind of long, but it's going to be very, very interesting. Like I told you guys earlier, now I've been doing the property tax eliminate property tax lawsuit package now for about 1.5 years, and I don't know how many I've so told. I don't really like to put a number out there because I got a lot of haters and people that don't really need to be up in my business. But I will tell you this: not one time has anybody got a response back from the attorney. Well, except recently. Ryan got Ryan's in our foreclosure rescue private page. He got a response back from the attorney, and we're going to check out the documents that they sent him, probably starting with the judge's order because it's really interesting, and then we're going to start with the document to dismiss. Hopefully, we'll make it through that today, and I'm just going to talk to you about it and explain what's going on, how I would handle replying to them. So that's what we're going to talk about today. So I got, who else here now? You guys let me know who's here. Who's in class already? So let me do a screen share and we're just going to get started right on this program. As soon as I figure out how to do the screen share. Okay, here we go. Screen share that one. So we're screen sharing this one, but I want to show you something before we get into that. This is actually the response. And I want to show you something before we get into that. So, okay. So these are all of the documents that they sent Ryan. And Ryan responded with this. He served them his eliminating property tax lawsuit package, and he included the notice of claim. Now, the way the package is structured, it's structured so that you can send them the notice of claim and give them opportunity to cure the problem or come to you and make some kind of a settlement offer, which is what's I think's been happening, because after people buy the document and I work with them, when they start getting into the program, all of a sudden they can't discuss it with me anymore. But they tell me they love me and all of that, and I got good reviews, which is fine, because I get it. The goal is to stay in your house. The goal in this property tax situation is to get, actually, my goal would be to get control of your deed. Some people are happy with not having to pay the property tax. And for each of you, it's up to you what's important. But keep in mind, if you don't have that deed and the title, then in 2 years or 1 year or whatever, they can still come back and start charging you again, which is what is usually done when you remove your property from the tax roll. A year or two, they put it back on there and just start charging you all over again. So to avoid all of that, we want to just go in and get it done right the first time, so you can go sit down and relax, and then you can put your title and your property deed in your Bible where it should be in the first place, before they came out with this great idea of registering your title in their office so everybody can have access to it. Now, one of the things that I want to talk about before we get into all of that is people need to understand how this works. And how this works is each state real estate deed transfer law mandates that the deed is supposed to be delivered to you after the sale. Now, did you get your deed? Hell no, you got your deed. What they did was what they call their constructive delivery, and they registered your deed in their office. Now, I'm going to ask you a question, and this is an important question. This is the question I ask people, when they're giving me a hard time. That deed being registered in the office is what triggers the property tax and all of that. The question is, do you know, after they registered your deed in their office, do you know what the first illegal lien was that was placed on your property? Think about it. Okay, time's up. The first illegal lien that was placed on your property is the mortgage lien that you've been paying for 30 freaking years. It was illegally placed on your property. On your property. And I'll tell you why. I know. I sound crazy. Your property was actually paid off by your signature when you signed the promissory note. They turned the promissory note into a security. They stamp pay to the order of, and pretty much turn it into a check. That's what the word most people understand. When you say security, people don't understand. They turn it into a check, and they process it through the Federal Reserve and was granted electronic credits. And Modern Money Mechanics publication says that they were granted 9 times the amount put into a demand deposit account. And then 1 time out of that account was written, so the bank got to keep the other 8 times. Yeah. So now I'm going to get back to the question. Do you know what the first illegal lien was that was placed on your property? Now, before I tell you the answer, I want to ask you one more question. I keep asking a bunch of questions today. If 4 or 5 people, we'll say 5 people, if 5 people own property, all 5 people would have to be present to sign a lien against that property, correct? That's correct. Okay, I'm answering myself now. That's all right. I am crazy. All 5 people would have to be present. right? Correct. So the fact that the bank accepted your signature on the lien, on the mortgage lien against your house, proved that you owned it free and clear for a very freaking short time, or the bank would not have been able to accept the signature on the mortgage lien. Bam. Now, I'll let you chew on that for a minute. And this is what I tell people on the Facebook page, that I can tell when attorneys are attacking me, because when I start posting my property tax stuff, attorneys get pissed and they come out of the woodwork saying some mean shit. I'm just like, dude, that's what I tell them. Okay, let me ask you something. I play football and I box. Those are two things not smart people do. So I have to keep it simple. So if all those people need to be present to sign, and you was the only one present to sign, then you owned your property free and clear before they threw you under the bus. Yep, that's pretty powerful. And there's no argument on it. There's no argument on it. And usually when I tell them that, they go sit the hell down, leave me alone. So these are all the so a couple of things. Not to pick Ryan's program apart, okay? Because Ryan is doing a great job. He's actually using the documents to address some other issues that he's got going on in his life, which is perfect, because that's what you should do. You need to be creative. Now, I don't say this a lot, because most people start being creative, and the first thing they do is turn everything into the conventional crap. And we can't be doing that. But if you can understand the documents, you can understand the challenge of jurisdiction, you can understand this stuff, you can use it to help you in other situations. As long as you're using this stuff and not falling back on the conventional crap, that's not going to help you. And so I'm real proud of Ryan. He's doing a great job. So one of the things that I wanted to there's a couple of things I want to suggest. Now, keeping in mind, I don't know where Ryan is in the process. So generally, the eliminated property tax lawsuit package is set up to where you can back them in the corner with the notice of claim. The notice of claim is actually the lawsuit, but it's just changed just a little bit so that it fits into the letter and not seem too crazy. But the goal is to show them everything, because you ain't trying to go to court. You ain't trying to argue, because once the arguing starts, the judge gets to help them. That's the way their system is structured. So we ain't trying to argue. So the way it's structured, you use the notice of claim to back them in the corner, and then you harass them on the phone for a while, and you try to get them to do what needs to be done before you pay the $400 to file the lawsuit. Now, if they've got you on the edge of the cliff and they're about to shove you over the edge of the cliff, you ain't got time for the notice of claim. You ain't got time for none of that shit. So you need to do like Ryan did and just get your stuff filed stuck right in their face. But make sure you add the notice of claim, because a lot of times they try to get out of it. Oh, well, we didn't get the notice of claim, blah, blah, blah. Then I'll be like, look, I'm not a corporation. I don't have to follow all them rules. And I can show you're damaging me, so I don't have to sit around and wait for all that to happen while while I file this other notice of claim, while you guys continue trying to throw me out of my house. So I don't have to do that. The other thing is, and I'll get to that here in a minute. I'm going to open it up. So the first thing I want to open up and show you guys is the judge's order. Now, I about cracked up when I saw this. This is the judge's order. This cause comes before the court on its own motion. So the courts are making its own motion pursuant to the court's standing order regarding assignment of cases filed in case number blah, blah, blah. The clerk of the court is, wait a minute. Standing order regarding assignment of cases filed in this case. Why is this case different than anybody else's cases? The clerk of the court is instructed to reassign this case to another district judge under the blind filing system established pursuant to the rules of this court. That's the rules of local court. The local court rules are not in line with the Constitution. So, Ryan, this is the first thing I would object to, the judge ordering, because basically what they're doing here And I know this because I've been through some shit. What they're doing here is they're allowing your case to get sent to the dirty judge. There's always a dirty judge to handle stuff. Apparently this judge didn't want nothing to do with it. So he wants it refiled through their fancy thing so it can be resent to the dirty judge that handles all the dirty stuff. That's my take on this, Ryan. So if I were you, I would definitely object to this. I don't care how long it's been. Okay. I don't care how long it's been. I would object to this because the judge is violating your rights. I mean, they don't know what rule. The rules that you need to follow are the federal rules of civil procedure. Okay. Those are the rules that everybody is supposed to be following. The federal rules of civil procedure. So, these local rules, why aren't they called federal rules of civil procedure? Yeah, you see where I'm going with this, don't you? Okay. If they're not the federal rules of civil procedure, it's bullshit and you're getting screwed. End of the story. Now, the other thing I wanted to talk about was the number of people here. And like I said, yeah, I'm not sending Ryan to the bench and by any means. As a matter of fact, he's going to be probably the second team leader on the property tax. Actually, he'll have to be the team leader because the other team leader on the property tax got to the point to where she couldn't talk to me anymore. And that's a good place to be, I'm sure. And she was real happy. She said, Coach, I love you, but I can't talk to you anymore. Okay, I get it. Great job. So she can't talk to me, so she can't be the team captain no more. So I'm going to send her to the bench. And I think I'm going to put Ryan as team captain for the property tax stuff because he's doing a great job. So my suggestion here would be to limit the number of parties you have on here. And over here, I need to add, and I'm going to make some upgrades to this package sometime in the next few days. And when I get it on my list, no, it's actually high on my list because I need to have this package ready to go. So when people invest in my limited property lawsuit package, they already know what they're finna get and what's going to happen and what's going down. So I'm going to make the changes to it pretty quick. But over here on this side, we need to have you reserve the right to amend as discovery suggests. That's what I like to put over here. And then over here, you can use less people, okay? Because at the end of the day, all of these people that are listed here are employed by the state. So what I would probably, now this is up to you to do, to figure out, because, like I said, I'm not an attorney, but I like to keep things simple. If the person that actually commandeered your deed and registered it should be number one, and then maybe the state would be second. Because that's or I don't know. You guys can figure that out. But here's the deal: the more people that you have here, the more you're going to have to. Everybody's going to be responding on their own. They'll have one attorney, or one attorney going to have a assistant. They're going to. So every time you have 6 people, then you could be looking at 6 responses, even if they're from one attorney. Even if they hire one attorney, they hire the paralegals to do the thing so that you get a response from each person. And then if you mess up on responding to just one of those responses, then they move to dismiss because of that problem. So, I would probably make this a little shorter so that, and then you don't have to serve all these people. Now, keep in mind, when you put over here, you reserve the right to amend, then you based on receiving your discovery, then you can still add people to it if you need to. But at the end of the day, you really shouldn't need to add anybody to it if you got the main players. And the main players would be the person who actually signed it, who actually registered your deed, and probably the state, because these other corporations work all under the state. But it's up to you guys. And like I said, we haven't had very many people get a response from them, so we don't really have a lot to go on. a lot of feedback, to go on like we do with the foreclosure stuff. So that's the first document I wanted to throw up and talk about real quick, so you guys can see. So what's going on here is hot potato. The judge don't want to get involved in this because he could tell from the facts in the document that Ryan filed that his legal team knows some shit. And when you come to the table with what Ryan came to the table with, you don't really have any respect for their bar member bullshit that they do to people to get control of them. So they know they're not going to be able to get control of you because you know too much. And the judge don't want nothing to do with it. I think that's what this is all about. And they need to get you over to the judge who handles the dirty work. And we'll see who that is. Maybe no judge will want to handle this. I don't know. But however it goes, Ryan will be ready. And that's for sure. So let's take a look at the motion to dismiss and squash service of process as to Marion County property appraisers, alternative motion to strike and incorporated memorandum of law. So let's make this a little bit bigger. Okay. So factual allegations. So here they run through. So this is, they just run through everybody that is mentioned as defendants, and then the factual allegations and procedural background through this action. You Ryan appears, and they just kind of talk through what Ryan is claiming. Now, this section would be perfect to start out your reply to them, because here they just outline everything that you're saying. And then you can use this to outline what you want to say, and then kind of go from there. But what you'll notice in here when we go through this is that they don't really address the issues. And one of the things that we're going to change on this is we're going to, and one of the things I'm going to change on it, and Ryan is already working on it, is we have to state a claim for relief the way the attorneys do. Now, generally, you shouldn't have to, because you got enough facts in here to get past that, but that's all they got. And for the longest time, I refused to do anything the way they do stuff. But I'm to the point where I'm like, you know what, if that's all it is. So I studied it for a week and a half, and oh my God, it's pretty easy. Stating a claim for relief. I have a video posted on my YouTube channel. You can go to my channel and punch in how to state a claim for relief and pull up the video. And it walks you through all of the facts that you need to know. And then I even have a guide that you can use for writing up your statement of claim. And it has all the elements and things that you have to touch on to make sure that you're doing it, just like one page. So I'm going to change that in the package. And so people won't have to worry about changing that when you invest in this package. But right now, if you have the package, you're going to have to change it. And you can go to my YouTube channel and you can see how that's done. So you can see here, they just go through the plaintiffs. So, they whine. They never really are clear, understand what you're talking about. But when we get done with doing the statement of claim, we're going to kind of change this a little bit, because really what this is real estate deed fraud. That's what it's called, what they're doing, real estate deed fraud. And one of the things they talk about in here is that we didn't really say what all parties did or whatever. So it's pretty easy. The first party that registered it, and that was the start of the real estate deed fraud. And then the rest of the people were conspirators to further along the scheme. I've been reading their stuff. So what you need to do is, when you read through this, make little notes. but the plaintiff claim is unclear to the defendant as to which each claim brought. So, then we need to break that down and be a little more clear. See, people look at their response and they get freaked out. And then I have to tell them, look, call me back when you're done breathing in a paper bag, okay? Because I don't work well with people that are all maxed out and hurrying and rushing around, acting crazy. They started out with BS. This is BS still. And if you take your time and go through it, you'll be able to break it down into BS, okay? Okay. So the plaintiff is I love Ryan. The plaintiff is allegedly seeking $10 million in damages, discharge the debt attached to the property. Nice. Most people miss that. Now, the debt that I'm talking about attached to the property is a debt that the state uses. The state uses your deed as collateral for loans from the federal government or whatever, and that's the fact, Jack. So I'm glad he put that in there, and probably reimburse the court fees and the deed relating to the real property. The only thing he didn't mention is title. We need to get the title in there too. So I'm going to have to change that on my thing. So the title's in there too, because he mentioned everything that I mentioned in there. So I'm not saying he missed it out. He left it out. But see, this is what we're doing here. From the real-time feedback, we're figuring out how to change this and make it so it has a little more heat. How much more heat do we need? As much as we can get. So he's seeking 10 million. He bumped it up from the 5.5. Discharge the debt. And in a separate section, the plaintiff's complaint states that he seeks to have his deed removed from the county recorder's office and returned to the plaintiff. And the actions of the defendant determined to be unfair, deceptive practices in violation of unspecified federal laws, in violation of the Fair Debt Collection Act practice. That's easy. That's the best thing to come with easy. You can prove that easy, okay? Because the attorney is acting as a debt collector and he's not working on behalf of the lender. So, and that's obvious by the signatures. Follow the signatures. The attorney is the only one that signed the shit against your property, the foreclosure shit against your property. So the attorney is the only one that's suing you. It's not the lender. That's the biggest mistake that most people make in foreclosure defense, is thinking that the lender is the one coming after them because the attorney told them it's the lender. Well, newsflash, the best way to tell when an attorney's lying is to check and see if his mouth's moving. Actually, I have a better one. I asked my neighbor one day, how do you tell when an attorney's lying? And she told me, he's breathing. I was like, holy crap. She's like, what? I'm like, you're slick. I said, you remind me not to mess with you. Yeah, the attorney's breathing. That's how you tell when he's lying. I like that. So you can't believe nothing that the attorney told you, or you can't believe nothing that you learned from the attorneys, or nothing that you learned from the conventional system. You can't believe none of that stuff. If you do, you will struggle in my program, because all of this stuff that I'm saying, I've learned from the 590 something people that's in my group, and from myself too. Yeah, I've been through some shit. So this is kind of cool. The attorney is complaining here about the public debt and have the court order an investigation into the defendants for RICO. He added that himself too, because I don't really have in mind to have them investigate them for RICO. That's pretty good. I like that. I think I might have to add that too. Award compensatory punitive damage in the amount of $10 million. And let me just find this one. So here they talk about, this is where he filed his complaint, and this is what he filed a complaint for. along with a complaint, he also filed his United States of American affidavit of state citizenship document. Now that document is on my website for $50. And I'll tell you what. So the best thing to do is to complete the passport process, and like I did, and get your passport card. Okay, but that's a little complicated right now with the COVID, the pandemic shit, and all that. And it probably would take twice as long, and most people don't have that much time. So I built this document that he used, affidavit of state citizenship, and it's just one document. I think it's maybe 2 pages, and you file it in your case to verify that you are a state citizen of the Republic state you're born in. Now, if you're from another country, you can tweak that to say you're from the country that you're from or whatever. Okay, it does not matter. What matters is that you let the court know you're not a U.S. citizen. A U.S. citizen is a citizen of the federal government. And nobody can be a U.S. citizen because nobody can be born in a fictitious corporation. Bam, there I said it. That pisses attorneys off too. Technically, if you were born in Washington, D.C., the 10 square miles or whatever, you could be considered a U.S. citizen if you really wanted to go there. In my opinion, nobody can be a U.S. citizen because the 10 square miles is like the 10 square miles, Washington, D.C. It's not the corporation, the fictitious corporation. So I'm going to go with what I said. Nobody can be born in a fictitious corporation until somebody proves me wrong. That's what we're going to go with. And the reason that you want to put that in there is because here's the deal. Here's the deal, Phil. Statutory court does not have, actually, it's an administrative court under statutory rules, do not have jurisdiction over a state citizen without an injured party. And they have no injured party because the attorney is the only person that signed the shit that they're using to try and steal your house. Or in this case of the property tax, the person that threw you under the bus was acting on behalf of a bar member. And usually they're trying to take your property because of all of that. And yeah, it all goes back to the same place. So now we'll get right down to it. The motion to dismiss, the legal standard, the complaint containing a short, plain statement of the claim showing that the pleader is entitled to relief under federal rules of civil procedure. Oh, they use the federal rules of civil procedure or when it's convenient for them. Otherwise, they like to use the local rules. We're catching on to that shit. To survive a motion to dismiss, the complaint must contain sufficient factual matter and state a claim for relief that is plausible on its face on Ashcroft versus, the evaluation of the complaint requires 2-step. And see, this all tells you right what you need to do. It tells you right what you need to do. You need to have a short, plain statement of the claim showing that the pleader is entitled to relief. And there's a couple of other things on there too. And there's one thing on there they don't mention on here too. That's on the document, that's on the video on how to state a claim for relief. And when you guys see it, you'll if you're paying attention, you'll figure out what it is when you see it. There's one thing that they never mention in their pleadings that's supposed to be there. One thing, they never mention that, but I did. So basically, Ryan, what they're talking about here is stating a claim for relief under Rule 12B. And that's one of the things that's missing, and we're going to correct that. And he just talks about that a little more. So all this is just talking about stating a claim for relief. And then here the argument calls for a short, plain statement of the facts showing the pleaders and evidence. Plain statement is considered attached to the complaint. It's a far cry from a short statement. So he's still complaining about you didn't do the short statement and plain free. And you notice he didn't say any of what you filed was not factual or at least hadn't said that yet. So next, plaintiff complains that the plaintiff mentions supposed violations of federal and criminal statutes. However, a private plaintiff cannot maintain a civil claim against a defendant for allegedly violating federal and criminal statutes. Well, I don't know about that. I think we're talking about the wording here. So maybe we can't get a claim for them violating federal and criminal statutes, but they violate the Constitution, and that's mentioned in there. And violating those federal and criminal statutes rob the court of jurisdiction, and they don't want to talk about that. So, and that's why we have that stuff in there. And the plaintiff has no action to authority to initiate a criminal action underneath the guise of, and see, here's the thing. You're not trying to initiate any criminal action. What you're showing is that the criminal action robbed the court of jurisdiction because of the fraud and the criminal action. You can't go into court with criminal action. I think it's called the unclean hand doctrine. Yep, that's it. That's where you go into court with dirty hands expecting to get something new. So we might want to throw that in there too, just to screw with their head. Let me check and see if anybody has any questions. So Pastor says Ryan needs to speak with me. I am next door. Pastor, whatever. Okay, well, he can come and get on this. Oh, there's Ryan. Hey, I'm here just thinking because I am 14 minutes late. I don't know if I'm tuning in to the delayed part 14 minutes ago or the lights court. I don't know about all of that, Ryan. I know that we've been going for 42 minutes right now, so and I can't make you run because I just made you the team leader for the property tax. So you're good. Hey, Nikki Weiss. Pastor Pennington is here. And Lee Grant. And John Castro. What's up, John? Glad to see you guys. Okay, let's get back to work here. So we'll go down a little further. The board just stated claim based on alleged violation of federal criminal statutes or the IRS code. The plaintiff's complaint is due to be dismissed with prejudice. Yeah. Well, you guys need to remember too, you get at least one opportunity to amend your claim without having to ask for leave of court. So also the plaintiff mentions intentional infliction of emotional stress, but fails to state facts sufficient to adequately state a claim for emotional infliction of emotional stress as to any defendant. So, and there you go. So we'll have to better state our emotional infliction of emotional stress, and that shouldn't be too hard to do. All you got to do is Google it. You'd be surprised what you find on Google. Defendant conducts an extreme and out. The defendant's conduct was extreme and outrageous. The defendant's conduct caused the plaintiff emotional stress. Yep, we can straighten that up. So outrageous. Oh, he just copy and pasted part of what Ryan wrote. So Florida's standard for emotional stress and infliction of emotional stress claims are extremely high. Okay, hold on. Florida standards? No. We're filing this in state and federal court. So the Florida standards don't matter about shit. Okay. And this is the part where you gotta be on your toes. Okay. He's talking about the Florida standard. The Florida standard don't apply when you use federal case law and when you're filing your case in federal court. Okay. The Florida standards don't apply. The federal court standards apply. It's not enough that the intent is torturous or criminal. It's not enough that the defendant intended to inflict emotional distress. And it's not enough that if the conduct was characterized by malice or aggravation would entitle the plaintiff to punitive damage. Yeah, they don't like any of that. So whether the conduct meets this high standard is up to the court. Yeah. So they just threw that out there because they knew they'd blown smoke on your face. So we'll have to clean that up a little bit, the emotional distress, and be more specific on pleading that. So that's going to take a little bit of work, a little Googling to figure out what the elements are for emotional stress. And then once you figure out what the elements are, then you can write up a little review about it using the elements and connecting them to your situation. That's how we do that. So next, he talks about the plaintiff's purports to bring his claim for slander of credit. However, claims for slander and credit are preempted by the Fair Credit Reporting Act under blah blah blah. Well, there you go. So now I'm going to tell you where you have to put that at. You see how this works? People get so nervous about it, but if you sat down and read it and make notes, they have to tell you everything that's wrong with your shit. Almost everything. They leave one or two things out so they can still kick you out of court. But they tell you almost everything. Like he's saying here. He's telling you what's missing. You didn't use we didn't use. I got to say we now because I didn't have it in the document either. The Fair Credit Reporting Act. Now, like I said, if you didn't have the Fair Credit Reporting Act in there, that doesn't mean that they can dismiss your shit. Okay, that's crazy. It's stupid because you got plenty of stuff in here to show that you have violated. But that's all right because we don't have a problem cleaning it up and making it smooth because I like it better when it's smooth anyway. So now he's saying they should dismiss the claim for intentional infliction of emotional distress. Next, the plaintiff purports to bring a claim for slander or credit. However, no, we didn't use the Fair Credit Reporting Act. Additionally, to the extent the plaintiff seeks to hold Marion County defendants liable in tort under state law. No, you're not holding them liable in tort under state law. You're holding them liable in under federal law. So he's saying that you failed to state a claim for relief by failing to specifically allege compliance with Florida statute. Well, here's the deal with Florida statutes, okay? Florida statutes do not contain the necessary elements to be considered a valid law. The Florida foreclosing statute is not a valid law because it does not have an acting clause, it does not have a title, and it does not have a body. The state constitution mandates that in order for something to be a law, it has to have an acting clause, it has to have a title, and it has to have a body. And those three things should be with it and not in some other book over there in the corner somewhere buried under a bunch of crap. So that's BS. The Florida statute is not a valid law. The foreclosing statute that they use in judicial foreclosures is not a valid law, and as such cannot provide jurisdiction to the court. So this statute cannot provide jurisdiction to the court to do anything. And he's talking about you to be specifically compliant to the statute. You don't have to comply to no statute. You have to follow the Constitution and common law. That's it. These statutes do not have the necessary elements to be considered a valid law, and therefore they cannot provide jurisdiction to any court to do anything. So here, an action, a subsection provides relevant in part, an action may not be instituted on a claim against a state or one of its agencies or subdivision unless the claimant presents the claim in writing to the appropriate agency and also presents such a claim in writing to the Department of Financial Services within 3 years after it accrues. Okay, writing to the financial services, that's ridiculous. That's ridiculous. I don't, Now, the proper agency that he's talking about, I'm assuming would be the Attorney General, because whenever you file a claim against the state, it's my understanding you have to serve the Attorney General. Now, this is moot because the Attorney General signed on and provided their information. So the Attorney General is well aware of what happened. I don't know, Ryan, if you served the Attorney General or not. And it really doesn't matter, in my opinion, because the Attorney General has found out about it some kind of way. Yeah. So he keeps talking about allegations that the plaintiff must have given notice pursuant to statute. Right. And so here's the deal with that. If you can prove that you're about to be violated or you're being violated, you're being injured, you don't have to give them claim for shit. Before a suit can be made, also notice after any allegations of that notice. Yeah, so he's whining about the fact that you didn't give them notice. So the court should dismiss it. The complaint does not speak of allegation that plaintiffs comply with section 5. Yeah, so this is ridiculous. So as far as giving them notice, they responded. So they knew, they found out. There's no notice needs to be given. They know now. So all of this is pretty much, oh, here it goes. Because the plaintiff did not specifically allege with Florida statutes, he cannot state any state law torts against the Marion County defendants. So, I don't know. I guess the attorney hasn't realized that you did file this in federal court, Ryan, right? Perhaps more fundamentally, though, their claims claim to rest upon the misapprehension of Article 1, supposed prohibition on direct tax from federal government somehow extends to tax assessment. So they're talking about, you're not talking about federal taxes, you're talking about state taxes. I think at this point they're just blowing smoke out of his face, because you're going after them for violating your constitutional rights. And what he said about the Constitution up here is ridiculous, because the Constitution states not once but twice that it's illegal to tax private property. And Ryan outlined it. What they've done was they took his private property and they reclassified it for the sole purpose of taxation. And that's exactly what they done. Now, in our response, we're going to be a little more specific about the real estate deed fraud and what the parties were doing, and we're also going to put together the plain statement of claim, so it can be done the way they like to see it. And then he's talking again about you didn't provide them with adequate notice. And alternative motion to strike. And it's a shotgun pleading. And so a shotgun pleading is just basically a pleading with a lot of holes in it. And this is pretty much what they file standard anyway. And he talks about the shotgun pleading here. See, if you guys look at this a little bit different, and when you're done breathing in a paper bag, you'll be able to see that they're telling you all the deficiencies, and you have an opportunity to correct them and refile your stuff. Remember how it goes. When you file something, the other party gets to respond, and you get a reply before the judge gets a chance to get involved. So here we talked about the shotgun pleading. I'm not going to spend a lot of time on that because all this is just a bunch of BS. Because basically, it's talking about the fact that that Ryan didn't state a claim for relief the way the attorneys want you to do it. That's all they're talking about there. So here, lack of personal jurisdiction and process, insufficient service and process. Additional American County Sheriff's Office moved to dismiss the plaintiff's claim for lack of personal jurisdiction, insufficient process. So they said lack of personal jurisdiction, insufficient process, and insufficient service of process to squash. They did not mention subject matter jurisdiction. There's two jurisdictions, subject matter and personal. Actually, there's a couple of more, but those are the two main ones that we deal with: subject matter jurisdiction and personal jurisdiction. So they're saying for lack of personal jurisdiction, but they had subject matter jurisdiction. Subject matter jurisdiction trumps personal jurisdiction. So, and it doesn't matter. One is all you need. And when you have one, you actually have both, in my opinion. Okay. But, so that's easy. This whole thing is ridiculous because the federal court has subject matter jurisdiction and personal jurisdiction, actually, because the process of service is ridiculous. Whenever someone complains about a lack of service and you're in court, then the judge, you said, well, you made it here and you responded, so that issue is moot. So this whole thing is moot. It's ridiculous. All they're doing is just blowing smoke out of your face. They're talking about serving the summons and all of that. And this stuff, none of the things that they mention in here are things that should get your case dismissed with prejudice. None of them. Okay, none of them. Your case cannot be dismissed with prejudice for want of form. Well, it can if you don't go after the judge and make a big deal about it. But in this case, you won't have to because we're going to make some changes to this and then see what they got to say. Can't wait to see what the next response when we get done with the changes and see what they got to say then. So, paraphrase slightly for brevity, the state with respect to the individuals and judicial district in the United States other than a minor incompetent person. Service, oh, they're still talking about the service. We're not going to spend a lot of time on the service because it's ridiculous. We all know about the service. So they're saying here that he failed to comply with Rule 4E as to Marion County property appraiser. He has failed to deliver a proper summons and copy of the complaint to. And see, this is all stupid shit. They all got it. They all looked at it. They all had a meeting on it. So all those things that can be corrected pretty easy. And I think Ryan's already on top of it. For each of these reasons, personal jurisdiction over Marion County appraiser. Oh, personal Oh, he didn't talk about subject matter jurisdiction. I wonder why. And in conclusion, the plaintiff complaint fails to state a cause of a claim for action and submissible shotgun pleading. The plaintiff's complaint amounts to an expression of disagreement over well-established law on state and local taxation of real property that cannot be cured through yeah. So he's saying here that that you messed up so bad it can't be cured through amendment. Additionally, the plaintiff's complaint is frivolous, vexatious, presents a discriminatory, false anti-tax connotation. Therefore, the court should dismiss the complaint with prejudice. Boy, they're really mad. They don't like it when you show them what's really going on with the property tax. So that's pretty much it for the first document. Yeah, how much time? Where are we at here? We're just a little over an hour. So I'm going to save the next document for the next meeting because I don't want to go too long on here. So let me go back. Stop the share. So, some of you guys, if you talk to me today, you heard me say, or you listened to my video, that we're going to have something on special tonight. And I'm going to put on special something that you guys like and need. If you're listening to this, I'm going to assume that you need this. So, here we go. This is what I'm going to put on special for the people watching tonight. If you're interested, yep, that's going to be on special. You guys can click on it and check it out. I'm still figuring out what I want to put it on special at. So this special is going to be for tonight and tomorrow. It's going to be it's right now, 9:56 p.m. on 1/30/2021. This special is going to be live until tomorrow afternoon at 12 noon. At 12 noon, the special is going to be over. And I'm going to put the special, I'm going to mark it down to $300. Now, what the hell? I'm going to give you guys a sweet deal since you've listened to me for a whole hour here. Half price, $250. $250 for the eliminated property tax lawsuit package. And in that package, you will get free of charge the jurisdictional challenge with an affidavit that you can use to stop any court processes if they're coming after you and they already have you in court, or if you're facing an eviction situation or any of that, the jurisdictional challenge with an affidavit will take care of that problem. And you're also going to get free of charge a copy of the magistrate judge reconsideration package. The reconsideration package is what you need to go after the judge when the judge throws you under the bus to help them. Okay. In that package, you have your motion for your objection / motion for reconsideration. You have the motion to recuse the judge and notice a claim against the judge. You got everything you need to slap the judge in the face for helping them. Because like I said, we've been figuring out how this works. And how this works is the judge helps them. And so when the judge helps them, we need to have a game plan for that. And that's what we've been putting together. Now, I also have another document that I'm going to show you guys that's already on sale for $200. I think it's on sale for $200. And this document I put together specifically to address specifically the judges taking control without judicial authority. And this document goes after the judge specifically for taking jurisdiction without legal authority. And it's pretty cool. Here, I'm pulling it up here. I'll copy and paste it and send it, paste it in the deal there. Okay, here it goes. And here it is. There you go. Now, for you guys facing, I know people are struggling with this pandemic crap, and a lot of people use their credit cards, to make it. And now they're trying to figure out how they're going to keep the credit card people from garnishing your wages and out of your bank account. So I put together, and this package has become quite popular. I put this package together for those people who are struggling with, there you go. So next week, we're going to go over another document. We're probably going to look at the attorney's objection to moot, and that's really funny. Then there's a second dismissal document that was written by, it looks like another attorney. So we'll go over that. And then the attorney general signed in an appearance. And what I would probably do is move to strike the attorney general's appearance, because the attorney general is a bar member. And I'm pretty sure the attorney general is not registered with FARA. I would just go out on a limb to say that. So yeah, so that's what I would do. I would move to strike the attorney general's notice of appearance, because the attorney general for the state of, I don't know, wherever the hell this is, Ryan is, I'm pretty sure it's not registered with FARA. So I'm gonna jam him up with that. You can jam them all up. That's what we do up in here. So that's all I've got for today, guys. I hope you guys found value in today's stream. And I think you guys can relax a little bit more now when you get ready to tackle this property tax thing, because you can see, okay, they have no defense. There is no law that mandates that you have to put your property deed in their office. So if there's no law that says you have to put your deed in their office, you should be able to ask for your damn deed back, and they should give it to you without a bunch of shit. That's it. And that's the thing. They trick you into filing your deed in their office, but there's no law that says you have to file it there. They forgot about that. Well, not me. I spent a lot of time finding their loopholes and figuring out a way to stick it back up in their face. So that's a pretty big loophole. There's no law that forces property owners to register their deed in the county recorder's office. And here's something else too. I have people in my private foreclosure rescue page, excuse me, that have all the documents to show that their loan was paid off. They have the deed release, they have all the paper to show, but the house still in foreclosure. So how does that happen? Well, what happens is the attorneys go to the county recorder's office and they get your property information from their files, and they use your property information to fill out a fake assignment, and they file that fake assignment against your property. It don't matter if it's paid off or not. You know how people tell me, oh, well, deadbeat should have paid their, you know what? You have no idea. A lot of people are in foreclosure and they're not even behind on their freaking mortgage. They're in foreclosure because these fraudulent attorneys went to the county recorder's office where the property deeds are registered and got their property information and filled out. And you know what? Anybody can go to their office and access your property information if you let them registered in their office. I was watching a scam on TV. My wife was watching this scam on Roku where these people were going and to the county recorder's office, getting information and filling out liens against the property and filling out all kind of stuff and taking over people's property. All because your information is stored in their, and they tell you, you need to put your information here so register it so that we can make sure that nobody gets on your lien or try to take over. You know what? And they're the ones that are doing it. Back in the day, everybody kept their property deed in their Bible. Nobody had to worry about registering it, and nobody could take over your deed unless they come out with a signed and notarized deed that was signed and notarized before and dated before yours. It was simple. But now the attorneys have all of these things and make people do all of this stuff so they can have access to your and so they can get that first fraudulent lien against your property. We talked about that at the beginning. So that's all I got tonight, guys. I hope you guys enjoyed the stream tonight. Leave me a comment down there. Please take the time to like and subscribe and ring the bell so the next time I'm ready to roll, you guys will get a notification.